You're welcome back. This is The Law. It's your legal light. It is your health law. I'm Samson Lardy Anyenini, and we want to do some digest of Francis Osei-Bonsu versus the Attorney General. This is a suit that went to the Supreme Court, and a 7-member panel gave a decision that removes some of the barriers put in the way of dual citizens by the Dual Citizenship Act. And the decision of His Lordship, Justice Emmanuel Yoni Kolendi, has been hailed as a piece of the Supreme Court's sort of legislation into our national affairs that is progressive and helps our dual citizens, Ghanaians who are elsewhere, but have been barred from holding certain positions. Professor Stephen Kweku-Asare, thank you so very much once again for making time to join us. He is the champion of the subject matter as far as this country is concerned. Thanks for joining us, sir. Please unmute your mic.
Sorry about that. Thank you so much, Samson, for having me once again. I appreciate the invitation to share some ideas and to discuss the case along with other things.
Right. We're excited that you're going to take us into the classroom this afternoon as we look at this decision of the Supreme Court per Justice Yoni Kolendi. So we say this is the decision of the court, Francis Osei-Bonsu versus the Attorney General. This is a shot in the arm for your advocacy, sustained advocacy over many years now, right?
Yes, Samson, it's a very big shot in the arm. And, you know, as an Aristotelian, when it comes to citizenship, I view citizenship not just as a status, but as a bundle of rights. Aristotle defines citizenship as someone who can participate in deliberative bodies and in the judicial process. So any decision of the court which removes barriers to holding public office, I support wholeheartedly. I find it to be progressive. It's a good thing when we are inclusive. All hands on deck is always good. So I am excited. We are moving in the direction of global trends. And so I want to give this court, the Osei-Bonsu court, some flowers for this brave decision. Samson, I also want to give former Chief Justice Sophia Akufo her flowers, because as far back as 2012, she said exactly what this Osei-Bonsu court had said. Unfortunately, she was in the minority, so her prescient dissent has now come to pass. And there's more to do, but we are making progress, and I'm very, very happy with this progress. This is a very good case for students when they read it in tandem with the Asare 2012 case, because this case and the Asare case is about constitutional amendment, statutory exercise of power, and how they intermingle with the Constitution. They raise questions about whether a constitutional amendment can be challenged on both substantive and procedural grounds. And we have made progress because the courts have said yes, and I'm sure we'll go through all that as we proceed.
Right. So as we know, the records show that you have been to the Supreme Court earlier on this same Citizenship Act of 2000 at 591. Briefly help us appreciate what your point was and what the decision of that court was. We know how helpful that decision has been for dual citizens as far as the requirement to have a card is concerned.
Yeah, Samson, very good. Let me share my screen with you here. And I don't know if you can see it.
That's right.
But if you can see it, I want to simplify this presentation so that everyone watching can actually understand the Osebonsu case, the Asari case, and then also what is next.
We're all ears and we are watching. Prof, take it over.
Okay. I start with a dual citizenship key events timeline. Then I'm also going to discuss the offices in question and those that are not implicated by this decision. Then the Osebonsu case, then the Asari case, and then what's next. In terms of evolution, let's start with 1996. This is when we passed Act 527. Act 527 is a constitutional amendment. It amended Article 8 and allowed or permitted dual citizens in Article 8.1, but then in Article 8.2, A to G, it actually barred dual citizens from holding 6 offices. And then people forget the most important thing. In fact, the Osebonsu court even forgot about this. And that is what triggered the dissent by Justice Kwamang. There is a delegated clause to Parliament. Article 8.2 gives Parliament the power to add additional offices. And so that's 1996. Then in 2000, Parliament exercising the power under Article A2G added 6 plus more offices. And I say 6 plus more offices because some of the, one of the clause would say a Supreme Court justice and justices of the Supreme Court. So it's, you can't put a definite number on it, or the kernel or any rank above that. So you can't put a number on it. So that's why I say the 2000 Statutory Act, the Citizenship Act, that's not a constitutional amendment, that's a statute. Parliament, by an ordinary majority, without going through the constitutional amendment process, added 6 plus offices. And then Parliament now delegated power to the Minister of Interior, to even add more offices. So in 2012, I went to court and I challenged a couple of things. First, I challenged Article 8.2 on both substantive and procedural grounds. And second, I challenged the 2000 exclusions on also both statutory and procedural grounds. I'm going to discuss the results later. But then in 2024, Osebonsu comes in and then he challenges the constitutionality of the statutory exclusions on only procedural grounds. So this background is important in knowing the distinction between Act 527 and Act 591. Even though they say Act, this Act 527 is a constitutional amendment, so it's pursuant to constituent hour, and this Act 591 is a statutory exercise of power or statutory power. Now, what are the positions that we are talking about? In Act 527 or Article 8.2, I've listed the positions. It goes from A2A to A2F, Ambassador, Secretary to the Cabinet, Chief of Defense Staff, IGP, Customs, Director of Immigration, and more important, Article 8.2G. Article 8.2G says, and any office specified by an Act of Parliament. So Article 8.2G is what we call in the law a delegated clause. Those who amended the Constitution in 1996 delegated that power to Parliament to add more offices. This is lost on the Osebonsu court.
That's right.
And that is why Kwamang said the court does not have jurisdiction. If the court had raised this issue, then they would have exercised proper jurisdiction, and maybe they would have dispensed with Kwamang's dissent. Now here's section 16.2. This is an act of parliament. It added more offices in the year 2000, Chief Justice and Justices of the Supreme Court, Commissioner of VAT, Director of General and Prison Service, Chief Fire Officer, Chief Director of a Ministry, and so on. And more important, there is also another delegated clause in this Citizenship Act. You see 16.2M says any other public office that the minister may by legislative instrument prescribe. So that is the law, the Constitutional Amendment Act 527, and that is Act 591 exclusions. So what were the issues in Osei-Bonsu? Osei-Bonsu went to court and he raised, and the Attorney General agrees with him. So it's almost like one party addressing the court.
Right. Prof.
They raised three issues.
Prof.
Whether or not Chapter 25 of the 1992 Constitution provides the exclusive procedures for amending directly or indirectly the 1992 Constitution. Two, whether or not Section 622A, this is on the Chief Justice and the judges of the Supreme Court, was passed in a manner that is inconsistent with and in contravention of Article 289(2). And then three, whether or not Section 16.2H to I, these are the other offices in the statute, of the Citizen Act was passed in a manner that is inconsistent with and in contravention of Article 289(2). Those were the issues. So Justice Poorman said, but what kind of issues are these? Issue one, according to Poorman, issue one is plain by reading, and it does not require the court's declaration for it to be so. We all know that you can only amend the Constitution by looking at Article 289. So that is not an issue that the court would waste its time on. And even if the court said it, so what? Issues 2 and 3 are also non-issues because nobody, not Parliament, not anyone else, has contended that Act 591 was passed in a manner that is consistent with Article 289 because Act 591 was an ordinary act of Parliament, and an ordinary act of Parliament cannot be passed in a manner that is consistent with Article 289. It is only when you attempt to amend the Constitution that you should follow Article 289. So it is a straw man to ask us whether or not Act 591 was passed in a manner that is consistent with Article 289. So he says the issues are sterile and do not raise genuine controversies. The relief sought by the plaintiff are premised on the mode of passage of Act 591. But the mode of passage is correct because it is an ordinary act of Parliament, and an ordinary act of Parliament cannot be passed in a manner that is prescribed in Article 289. So the court has no jurisdiction. And then in response, Justice Kulendi, I don't think he addressed Poorman directly, and that's one of the problems we have on our court. They don't speak to each other, so Poorman has dissented, and I believe if the court had advertised its mind to what Poorman was saying, they would also have known that they are missing Article A2G. But be as it may, Justice Kulendi basically says, the court has jurisdiction because the parties have invited the court to do two things. You can see that in paragraph 30. One, to ascertain whether Section 16.2 directly or indirectly amends Article 8.2. If so, then the court is also to determine whether the amendment was passed in accordance with Article 289 or 291. This is what Poorman calls a straw man because Parliament was not amending the Constitution, so it is unreasonable to even ask this question. But let's move on. That's the jurisdictional argument. It's a 4-1 decision because Poorman indicated that the court had no jurisdiction. Now, my view on the jurisdictional battle between Poorman and the court is one, the majority misses the rationale for its jurisdiction, which is the interpretation of Article A2G that was provided by the Asari court. That's the issue. Strangely, neither the parties, the court, or even the dissent mention Article 8.2g, Section 16.2 of the Citizenship Act does not purport to amend Article 8.2 directly or indirectly. So Puaman is essentially correct. Section 16.2, however, was enacted pursuant to Article 8.2g, which delegated power to Parliament. So the issue should have been, was there a proper delegation of power in Article 8.2g? Let's go to the holding by Justice Kulendi, which I agree with. I totally agree with this conclusion, even though I don't agree with the analysis leading to the conclusion.
All right.
Justice Kulendi eloquently and elegantly said, we find that Section 16.2a and 16.2h to L constituted amendments to the Constitution. Thus, they ought to have been undertaken through the prescribed channels of formal amendment as prescribed under Articles 289 and 291. Thus, the said sections are unconstitutional and are hereby stricken down. So the effect of this decision is now dual citizens can hold those 6+ offices that they were barred from in the Citizenship Act. That's progress. That is inclusivity. And I like that. Now, there's a concurring opinion by Justice or Chief Justice Tokonu, and he basically says whether Section 16.2 constituted an amendment of the Constitution should be dealt with in 2 layers. First, all of Section 62 did not constitute a constitutional amendment on account of it adding the list of officers. However, Section 16.2a, which deals with the Supreme Court, the Chief Justice, and the Associate Justices of the Supreme Court, that particular section amended Article 128.4 because Article 128.4 provides the qualification for being on the Supreme Court. And any addition to that qualification has the effect of amending Article 284. So in her mind, Section 16.2a amended Article 284, Article 128.4, and then she also ultimately agrees with the majority. She says there's no support of a meticulous attention to any constitutional measures applicable to the list of other offices. So she concurs with the majority that Section 16H2L of Act 2000 should be stricken down.
Right.
So that is the Osei-Bonsu case. And I have indicated why I support the conclusion, but why I think the analysis is incorrect. And to understand why I say the analysis is incomplete, maybe let's also look at the Sari case and to become clearer. Of course, if you have any questions, Samson, just come in at any time.
Right. If you don't mind, so that we take our audience along with us in a manner that is smooth, let's retrace our steps.
Okay.
The first position is that, as you explained to us, is that the Constitution 1992 completely barred dual citizenship or dual citizens from holding any positions in Ghana, correct?
Yes, absolutely. And you can see it here on this slide. I said Article 8.1 of the Constitution 1992 outlawed dual citizenship for those who are over 21 years old.
Right.
It basically says, if on attaining age 21, if you acquire the citizenship of another country or you retain the citizenship of another country, then automatically you will give up your Ghanaian citizenship. So that is Article 8.1 of the Constitution in 1992.
Good. And then in 1996, we then introduced an amendment that said you can hold dual citizenship. However, if you make that election, you will not be able to become an ambassador or high commissioner, secretary to the cabinet, chief of defense staff or any service chief, inspector general of police, commissioner, customs, excise and preventive service, director of immigration service, and any other office specified by an act of parliament.
Precisely. So you would see here, I say Act 527
right.
repealed Article 8.1 in the 1992 Constitution,
which said
allowed dual citizenship. So if you look online at the Constitution now, you are not going to see the prohibition of dual citizenship. You are only going to see the amended Article 8.1, and the amendment Article 8.1 would say a Ghanaian can hold the citizenship of another country. However, Act 527 also introduced Article 8.2. Article 8.2 describes the positions that you have enumerated,
right,
and the delegated power in Article 8.2G, which says not only can't you hold these 6 offices, but Parliament can add to these offices.
Right. Then in 2000, we make the Citizenship Act. And the Citizenship Act now adds on a new list, which you have referred to. This new list is what Francis Osei-Bonsu has now gone to the Supreme Court and successfully gotten the majority of the courts, 6 out of 7, to shoot down, correct?
Yes, definitely.
With only Justice Kwama dissenting.
With, yes, Act 591. And then it also says more public office holding exclusions were inserted by Section 16.1. And then this is what the court in Francis Osei-Bonsu has said, no, you can't do that. Parliament, if it wants to exclude people, then it has to go through Article 289.
Correct.
But the court does not explain what Article 8.2G means, because Article 8.2G says Parliament can add to the offices.
That's right. So, yes.
And that is what Parliament did.
Right. So that's understood. So this new law in 2000 called the Citizenship Act then introduced a new, or what you call the additional list of Ghanaians who can hold citizenship of other countries together with their Ghanaian citizenship, but cannot hold certain offices. The new offices that were added were Chief Justice and Justice of the Supreme Court, Commissioner Value Added Tax Service, Director General Prison Service, Chief Fire Officer, Chief Director of a Ministry, and a person of the rank of a colonel in the army or its equivalent in any other security services. And then he said any other public office that the minister may by legislative instrument prescribe. So these new additions are what the Supreme Court now in April 2024 has struck down and removed as unconstitutional. So from the 24th of April 2020, from the date of this decision, you can be a dual citizen and become a Chief Justice, become a Justice of the Supreme Court, become a Commissioner Value Added Tax Service, become a Director General Prison Service, become a Chief Fire Officer, Chief Director of a Ministry, or go to the rank of a colonel in the army or its equivalent in any other security services. Is that correct, Prof?
Yes, sir. That is very correct. Exactly correct. Yes.
Right. So this is where we are. And you say, why is this decision a progress when all you have championed for is that the entirety of the exclusion list as found in the Constitution should be done away with?
Yes, it's progress, Samson, because progress can be incremental. Second, I intend to discuss the Asari case. Third, I intend to make a distinction between constituent power and constituted power. So, for instance, constituted power is if the original constitution included any offices that dual citizens cannot hold, hypothetically, then the Supreme Court would have no power to say those positions are unconstitutional, because those positions were inserted by all Ghanaians through a referendum, and the Supreme Court cannot touch that. So, for instance, if the voting age is 18, the voting age of 18 was inserted in the Constitution by a referendum. It was not inserted in the Constitution by a constitutional amendment. It was not inserted in the Constitution by an act of Parliament. The Supreme Court has no power to say the voting age of 18 is unconstitutional. That type of problem can be addressed only by an amendment to the Constitution. And this is the argument that we had in 2012 with the Supreme Court. So if you want me to show that a little bit, maybe some of these issues may become clearer to the audience.
So,
especially
Prof, proceed on that, but do you also, like Justice Yoni Kolendi, applaud the Attorney General when, in this matter, he files his arguments, but it's not arguing against the applicant or their lawyer, Bright Ochiri Ejokum, but rather supporting the arguments that they make, which was applauded by the courts?
Yes, I do. I really do. This is the first time that I've seen the Attorney General actually agree with the plaintiff, that the plaintiff is essentially correct. Now, having said that, I also don't like the idea that two parties are in the court and saying the same thing, and there's nobody challenging them, because if you do that, then the chances that the court does not see the total picture is higher. Because if there was somebody there, like an amicus curiae, amicus, then that amicus may have pointed out Article A2G, which all the parties somehow skipped.
All right.
And this decision would have been more accurate with other people. So yes, I agree, but I just don't like the idea that two parties go to court and agree and the Supreme Court just agrees with them. No,
okay,
I don't like
Prof,
that.
let's proceed.
So let's see. We've talked about Article 81, Act 527, Act 527, and then we talked about the statutory exclusions. Then one of the things that was also important was that there was LI 1690, which provided that dual citizens must hold a dual citizenship card. So this was in the Citizenship Regulation 2001. So when I went to court in 2012, I challenged the constitutionality of the public office holding exclusions imposed on dual citizens on substantive and procedural grounds. That case produced a dissent by Sophia Akufo. That dissent has been treated by some courts, some of the Supreme Court courts, as the main holding, and even as by the Attorney General as the main holding. I'll show you that shortly. To me, the Bonsu Court has formalized this trend of upholding the dissent by Sophia Akufo and overruling the Asari's majority position on Article A2G and therefore on Section 16.2AH to L of Act 591. So all I'm saying is the court basically said Sophia Akufo is right and the majority was wrong in Asari with regard to the procedural issues, not the substantive issues. The substantive issues, they agree with the Asari court, but the procedural issues, they disagree with the Asari court without saying that. Otherwise, their decision it's incomplete.
Okay.
Now, here are the substantive issues in Asari. First, I asked whether a constitutional amendment must embody the values of the Constitution that it's amending. Because I said in the unamended Constitution, there were some values: equal protection, dignity, participation. and any amendment to the Constitution cannot violate these values. That's what I mean by substantive challenge. So I said they violated Article 17, 15, and 55. The Osebonsu court misses Article 55 and they only talk about Article 17 and 15. That's a minor point. Then procedural issues. The procedural issues are important because that's where there was a lot of dissent on the court. Whether Article A2G impermissibly delegated power to Parliament to add to the list of offices. That was my question one. Question two, whether Section 16.2A, H to M, these are the offices listed, were unconstitutional for not using the steps in Article 289. C, whether Section 16.2M impermissibly delegated power to the minister to add to the list of the offices. And then four, whether any regulations that call for dual citizens to carry cards that single citizens do not carry is constitutional or is unconstitutional. And so, here's what the court said. First, on the substantive issue, the court said, yes, the amendment is okay. There's nothing substantively wrong with that. The court will not question the putative loyalty framework because that is legislative wisdom. The affected offices anyway are not political. You know, the court, when it was addressing my challenge on Article 55.10, said the positions that we have listed are not political. They are not like going to parliament or being a president. Those are the political posts according to this court. So that's a very important point because the Asari court understood the distinction between Article 94.2a, which deals with political offices, and the Article A2 positions that dealt with non-political office. This was a 9-0, total annihilation. Asari was completely annihilated, 9-0. So that was one. Then let's go to two. Whether Article A2G impermissibly delegated power to Parliament to add to the list of offices. The court majority said no because the delegation is proper and the delegation has boundaries. What are the boundaries? According to Justice Dateba, the boundaries are to be found in the spirit of the Constitution. And then he gives an example. In the example, he said, if Parliament, for instance, added all public offices, then that would be unconstitutional because that will violate the spirit of the Constitution. This is a 7-2 decision because Sophia Kufu and Rose Owusu dissented. They said, no, that cannot be correct. And I'll explain why they say that. Then, whether Section 16.2a, A to M, were unconstitutional for not using the steps in Article 289. The court said no, because Parliament was exercising delegated power in Article A2G, so that they have done nothing wrong. They need not follow Article 289 because they have been delegated the power to add to the offices without going through a constitutional amendment. Then here is whether Section 16.2M impermissibly delegated power to the minister to add to the list of offices. The court said yes. Why? Well, because Parliament itself has just been delegated power, and therefore they don't have power to delegated power that has been delegated to them. The phrase used by Justice Dateba is delegatus non potest delegare. So that was a 7-2 because Atuguba and Akotobamfu dissented. So now you see, within the same decision, we have dissent by different people. And this is how I want students to read court decisions to notice these nuances. So this 7-2, the dissent were by completely different justices. And then the last one, whether dual citizens should carry cards. And the court said no, or the regulation is unconstitutional because some citizens cannot be compelled to carry cards. Again, it's a 7-2 decision, and the dissent is Atuguba and Akotobamfo. Now, I want to show you what the court said about the delegation case.
Right. So let's try to summarize that so that we can get to the end where we would look at what should be the policy outlook going forward as a country in the manner the Supreme Court has started to shape for Ghana.
Okay, so let me quickly. So the delegation, this is what the Asari court said. This is Dateban speaking. What gives me cause for concern is the power given to Parliament under Article A2 to specify any office from which dual citizens will then be disqualified from holding. In my view, the spirit of the Constitution imposes a limit on the legislative discretion thus conferred. For instance, if Parliament were to enact a law specifying that dual citizens are disqualified from public office, that would be an unconstitutional infringement of Article 5510. This is one of the most important holdings in the Asari case. Now, the dissent, Justice Sophia Akufo, she totally disagreed with this, and this is what she said. Since the Constitution sets out a certain and specific list in Article 8.2, it follows that any addition to the list would amount to an amendment of the Constitution. It is for this reason that in his statement of case, the plaintiff seeks to argue that the Act of Parliament stipulated in the clause, that is Article A2G, is one that must necessarily comply with the provisions of Chapter 25 of the Constitution. This is Sophia Akufo. Hence, if Article A2G was intended to create an exception to the requirements of Article 289, it should have been so stated therein expressly that in respect of the clause, the said requirements are accepted. Clearly, this was not done, and therefore, there will be no justification for reading any such exception into the provisions of Clause G, Sophia Akufo. To hold otherwise would be very dangerous and make a mockery of constitutional provisions such as Article 8.2, which particularize specific matters, thereby eventually reducing the Constitution to the status of an ordinary statute, as evidenced by what Parliament has attempted to do in Section 16.2 of Act 527. For the foregoing reasons, I'm of the view that the addition of the offices in Section 16.2a and then H to L to the list of proscribed positions is unconstitutional. I would therefore declare those provisions null and void. This is exactly what Kulendi also said.
Has done in
Post-Asari,
April.
Post-Asari, look at the Anyenini case. If you look at the Anyenini case, Anyenini versus Attorney General, 2020, Justice Doje, he even adopts Sophia Akufu's position. He says, insofar as Section 13(1)A of the Impugned Act sought to add to the disqualification of lists affecting citizens who owe allegiance to countries other than Ghana, it is unconstitutional. So the OSP, they say the special prosecutor cannot be, a dual citizen, owe allegiance, but the Supreme Court said the two things means the same. So, but Justice Doje says that is unconstitutional. And then Samson, you can even see that in 2019, Gloria Akufu wanted to amend the OSP bill because she said, in line with Article 289, as espoused by the Supreme Court in the case of Asari versus AG, she was relying on the Justice Sophia Akufu dissent. So this is a dissent that has become more powerful than the majority opinion. Let me conclude.
Right.
It's therefore wrong for the Osei-Bonsu court to say, however, since these issues were not in contention in Abef case, they were in contention. Justice Dateba held that the delegation to Parliament was proper and is subject to the spirit of the Constitution. That is not obita, that was the rule of law. It was this holding that triggered Justice Akufu prescient dissent about bastardizing the Constitution. The court should have been forthright to say it's overruling Asari, that delegation to Parliament, like the delegation to the minister, is unconstitutional. So here, Samson, to answer your question, this is a quick overview of the powers behind exclusions of dual citizens. Dual citizens are now excluded based on allegiance and based on dual citizenship. All the conversations that we have had to now is just based on the dual citizenship. There's another one which is based on allegiance. That is Article 94(2)(a), and I show you that that was in the original constitution. Constituent power means in the original constitution.
Right.
Constituted power means it was based on an amendment. And the positions that dual citizens cannot hold because of allegiance interpretation include the president, vice president, minister of state, deputy minister of state. So executive, they are excluded from the executive. Speaker of parliament, member of parliament, so they are excluded from the legislature. Member of EC, member of the public service, member of NCC, member of lands commission, member of regional commission. So they are excluded from constitutional commissions, and then they cannot be founding member of a political party, they cannot be executive member of a political party, they cannot be a leader of a political party. So they are excluded from the leadership of political parties. And then recently, we have the Special Prosecutor Act. So what we can do now, Parliament can get involved.
Yes.
Because
but Prof, before we introduce Parliament to amend the Constitution itself again and open sort of the floodgates for dual citizens to have equal rights to occupy the offices that they are presently prohibited, don't you take the view that by the Osei Bonsu decision, as led by Yoni Kolendi and Justice Gertrude Tokonu, all these other acts, like Section 13 of the Special Prosecutor Act, which also has a prohibition, if the courts were presented with such an act, it will hold that these are also not right.
Yeah, but the court should not be even presented. This is what the role of the Attorney General is. The Attorney General should step in and say, by parity of reasoning, the OSP Section 13 is unconstitutional. This is what I was saying, that Sofa Akufo attempted to do here in line with Article 2. So you don't have to take everything to the Supreme Court. The Supreme Court has given a rule of law that dual citizens cannot be excluded unless you go through Article 289. So any act that excludes dual citizens, whether the court mentioned it or not, automatically is taken down.
So now let's drill down to what your view of the policy outlook should be. Because as you have outlined, the Supreme Court has been very clear and forward-looking that this is not right. So what should be our policy outlook so that we don't have to end up picking all of these one by one, going back to the Supreme Court and say, strike this down, strike that down?
Well, so that's why I've made a distinction between these things, you see. So anything that excludes based on statute, right here, Act 959, Act 5 now, those are all unconstitutional. We don't even have to talk about them. They're all dead issues now.
Okay.
Now, then we go to the Constitution. The Constitution has Article 94(2)(a) that was in the Constitution even before the 1996 amendment. And then the Constitution has the 1996 amendment. Those two things in the Constitution have not been touched by the court at all. And it is those two things that Parliament, in my opinion, has the power to amend, because if you go to the Asari court and also the Kulendi court, they say they are not willing to question the legislative wisdom of Parliament. If Parliament has adopted a putative loyalty framework to exclude some of the citizens, then the court will not get involved in that. I tend to disagree with the court, at least with respect to Article A2, but that's what the law is. So now, the Supreme Court has put the ball in the bosom of Parliament, in the court of Parliament. So Parliament must now come in, and Parliament, of course, has been working on a bill to this effect. And I show you what Parliament has been doing. On June 2nd, 2021, Parliament proposed a private member bill sponsored by my good friend and brother, Kennedy Osei, that would repeal Article 8.2 and Article 94.2a. That was in June 2021. Then, as required by the Constitution, it was first gazetted on July 9th and republished in the Gazette on October 11th, 2021. Then, on June 2, 2022, it was read in Parliament. It's called the first reading.
Right.
And as the Constitution requires, immediately after the first reading, the bill has to be sent to the Council of State for advice. That was done on June 2, 2022. And the Council of State has only 30 days to give the advice. The Council of State met some of us. I met the Council of State. I made a presentation and so on and so forth. So the Council of State advised on July 3rd, 2022, that yes, this makes sense. Why are we excluding some of our citizens? Let all our citizens participate. And the Council of State, this is made of the wisest men in the community. The wisest men in the community said, let us not exclude any of our children. Let us bring everybody on board. They did that on July 3rd, 2022. Then nothing happened till 1 year. The bill was referred to the committee July 13, 2023. Here we are in June 2024. We ask when will be the second reading and the third reading. The second reading and the third reading is when we vote on this bill. So let's bring the bill to the floor to vote for it. As far as I know, ex-President John Mahama has said he supports the bill, and he has said so publicly. President Nana Akufo-Addo says he supports the bill, and he has said so publicly. Vice President Mahmoud Bawumia, my very good friend, my brother, has said he supports the bill. He has, I don't know, I think he has said so publicly, even publicly. So what are we waiting for? It is time to bring the bill to the floor when the House resumes on June 11th and to vote on it. And I say here that today, dual citizenship is an unexceptional status and poses no threat to Ghana or to Ghana's institutions. It is part of our heritage because, look, Osajifo Dr. Kwame Nkrumah was a dual citizen. He was a citizen of UK, citizen of Ghana, and citizen of Guinea and Mali when they signed the Ghana-Guinea-Mali Compact. So it's a part of our heritage. Let's embrace it. It reflects our immigration story. We have a lot of skilled people going out, acquiring citizenship of the other countries and coming back. So it reflects our immigration story. We must leverage it. We aspire to be a liberal polity. We must banish our liberal credentials. We must shake off the imagined fears that we entertain about allowing dual citizens to become equal members of the political community. We must, like most of the world, move away in form and substance from the notion that dual citizenship is a moral anathema and a problematic status. It is an unexceptional status in today's mobile world. We must cross the bridge of doubts, fears, suspicions, and the imaginary walls that underwrite the exclusion of many of our fellow citizens from the political community. And Samson, when you ask for the policy rationale, I've given many grounded in economics, sociology, liberalism, globalism. Let's only talk about the remittances that people outside the country bring to us.
Right.
Look, when they want to do something like the Ghana card, they are willing to send people all over the world to give them Ghana card. Why are you giving me Ghana card if you don't trust me that I can be in parliament? I mean, I can't reconcile the conflict. We have a year of return. We make a big deal of the year of return. Oh, we love our diasporans, blah, blah, blah. But you cannot be a fire officer. You cannot be in this. You cannot be a that. Look at the way we celebrated Steve Wonder when we gave him citizenship.
Right.
Are we, by our logic, saying we are poisoning Steve Wonder's ability to participate in his first country or in his mother country? No, obviously not. Our rhetorics on dual citizenship must match our actions. And the only way I can see a reconciliation, Samson, is for us on June 11th, when Parliament resumes, is to vote for Kennedy Osei-Nyako's bill resoundingly. Any more waste of time in voting for the bill is not progressive.
And when that bill is eventually passed into law, you can be a dual citizen and be a member of parliament. You can be a dual citizen and be a vice president, be a minister, be a president.
Yes, my work with the committee indicates that they have made an exception for the president and the vice president.
Okay.
So all other positions, minister, deputy minister, cabinet, speaker, electoral commission, regional leader of politics, all of those things will be gone. The only thing that will remain on our book is president and vice president. I consider that progress, even with those exceptions. That's very good. That's good.
All right.
At least we've made progress. We've cleared a lot of hurdles, and then we can live with the president and the vice president.
Thank you very much, Professor Stephen Kweku Asare. They're helping us to digest the judgment of the Supreme Court of April 2024, Francis Osei-Bonsu versus the Attorney General, and the lead decision was by Justice Yoni Kolendi, Emmanuel Yoni Kolendi, and there was a supporting decision, concurring opinion by none other than the CJ, the Chief Justice, Gertrude Araba Esaba Saki Tokonu, and so by the decision of Justice Yoni Kolendi, Justices Mariama Owusu, Aka Yensu, Barbara Aka Yensu, Justice Kumsin, George Kumsin, Justice Dewu, and then also Saki Tokonu. And you had Justice Poorman making a dissenting opinion in that decision. Professor Stephen Asare says this is progressive, and the Supreme Court has indicated what Ghana's policy as far as dual citizenship is concerned ought to look like. And Parliament must finish that business by passing the bill, sitting in Parliament, to remove all the impediments in the way of dual nationals of Ghana. It was when I did the case to get Ghanaians living abroad to vote that I realized how much Professor Kweku Asare is talking about economic sense, how much they contribute only by remittances alone. There's been a time when they have contributed more than twice what we generate internally. Let's look at this and look at it carefully. I'm Samson Lardy Anyenini. This is the law. It is your legal light. It is your health law.